Court Teenagers Report is now in session. All those having business before the court draw near. The Honorable Judge James Cedric Simpson presiding.
Court does call the case of Affinity Investments versus Willie Cater.
Good morning, Your Honor. Ronald Ruark for the plaintiff, Affinity Investments.
Good morning, Your Honor. Excuse me, give me 1 minute. Had to run out my job. Good morning, Your Honor. Willie Cater here.
All right. And we're here on your motion to stay the writ.
Yes, sir.
Correct?
Yes, sir.
All right, I denied it. What's your basis for stating the writ?
My basis of stating the rent, Your Honor, is I don't have any problems with paying what the rest is owed to my landlord, but I'm also entitled to a rental property that meet the basic structure, health, and safety standards also of living there, you know, and that's not being complied with my landlord at all on several things.
But, sir, that would be a defense that you would raise in the primary case. Your basis for staying the writ would be payment.
All right, Your Honor, I put 1 month rent in escrow, and I have the rest of the payment also that I would rather put in escrow than to give to the landlords because of this reason right here. Now, I just feel like if I'm out here doing everything I can, even I fell behind, okay, cool, but I'm paying you now and I'm paying my money. I am also entitled to make sure that the home that I stay in is
that needs to be raised, sir. I'm not going to litigate the case again.
Okay.
And you have to just separate that out. Counsel, how much is owing?
Your Honor, there's still on the original judgment of possession, there's $2,730 that is still owed, and a total
which I have.
Mr. Cater. Go ahead, counsel.
And a total altogether for April, May, June, and July, he still owes over $11,130. $2,730 on the judgment.
No, I don't. I don't owe. Oh my God. I just answered that. No, I don't, Your Honor.
Mr. Cater. You know what? You keep talking. I'm just going to end this hearing and deny your motion.
Yes, sir.
Am I understood?
Yes, sir.
Counsel, how much is owing on the judgment?
On the judgment, $2,730. Mr. Cater did pay $2,100 on June 16th and $2,050 to the court, which I request be released to my client. So $2,730.
Oh, I understand that, but the $2,050, is that, have you already subtracted that to get to your $2,700 or no?
Yes, I have, Your Honor. He paid $4,150 on the judgment.
After I just want to make sure I'm clear. After the $2,050 is paid, then there's still $2,730?
That is correct, Your Honor.
All right. Is there anything else?
Only that he owes an additional 4 months rent. He keeps getting further and further behind.
No, I don't. Do not owe it.
The last time he said he had paid, the check bounced.
No.
I know, I was here. Mr. Cater, I already warned you once.
Yes, sir, Your Honor.
You keep saying yes, sir, but then you keep talking. There's not a basis for me to stay the writ in this case because the judgment is not even satisfied in terms of the payment into escrow. Even the payment into escrow, if paid to the landlord, would not satisfy the judgment in this particular case. And so there just isn't a legal basis. There just isn't a legal basis for me to do so. And so I'm not going to do so. Motion to stay the writ is denied. The writ will issue escrow to the plaintiff.
Thank you very much, Your Honor.
Mr. Simmons, can I say one thing?
I don't know why you would want. You say what you want to say and be very careful what you say to me.
Oh, no, I ain't never been disrespectful to you.
You interrupt.
On,
Go ahead.
I would rather pay the amount that's owed to the court. Is that okay?
Not at this point. You need to pay the
Uh,
landlord on the judgment. To stay the writ, you need to pay the
Yes, sir.
amount on the judgment. It's
You- and-
simple.
And the only reason I state that, okay, they will have their payment Monday, Your Honor. Thank you so very much.
Well, you got to beat the writ there. Thank you.
Thank you, Your Honor.
Can I ask you when the writ will be issued?
Mute him and kick him out of my courtroom. I'm done with him.
Thank you.
Boot him. Court calls the case, Danbury Park versus Sharonda Hill.
Good morning, Your Honor. Jill Bauer appearing in place of Lou Maskell for legal services on behalf of defendant Sharonda Hill. I'm not sure if Mr. Piper's office is here, but we did have a discussion about agreeing to a 2-week adjournment.
Your Honor, Mike Zappin on behalf of the plaintiff from Piper Law.
Okay. You guys don't really want to go next, do you? But anyway, go ahead. All right. You want a 2-week adjournment?
Yes, Your Honor.
'28th, that one. All right. Adjourn this matter July 28th, 2023, 9 a.m.
Thank
Thank
you,
you, Your
Your Honor.
Thank you, folks. Court calls case, Douglas Eichenhauer versus Shirley Totten.
Morning, Your Honor. John Calvin appearing on behalf of the plaintiff.
Ms. Totten?
Yes, I'm here.
Okay. All right. Where are we on this case, folks?
Your Honor, we appeared last Friday and explained the situation. Ms. Totten has been living with the plaintiff, and you asked me to send a copy of the lease to show that she was not on the lease. So we emailed that over on Monday. And this is just a termination. The parties have been in a long-term relationship, but that relationship has broken down, long since broken down. My client sent me a message yesterday that she's actually forged his name on a check and cashed it, and also used a credit card without authorization. So he's adamant at this point that he just needs her removed. We're not asking for any money or anything else. We're just asking for her to be removed from the unit.
Ms. Totten, what is your position on this now?
Well, to be clear, 2 things that he stated last week are not true. I even went to the mental health department. I've never been under any mental health issues, unlike him, but that's another story. Our daughter is not on board with this. She's afraid to say anything to her dad. As far as the check, he gave it to me and I put it in our joint checking account, and every penny is
Okay,
there.
ma'am. Okay, let me stop for a moment. How old is the daughter?
She's 28, but she's not on the
Okay.
lease either. He holds this over our head like a cat and mouse game. I'll
Okay.
tell you my week. Sunday, we went to the park, him and I and the dog, like always. Got an ice cream, got Subway. Monday, he was irritated that his lawyer had to give me a copy of the lease. Tuesday, he had teeth pulled, and I had to drive and take our daughter to work and go and get his prescriptions. Wednesday, he told me if anything happened to me, if I got sick, he would let me be there. Then yesterday, he tells me he'll buy me a tent. It's a flip-flop.
Well, folks, I guess if I wanted to deal with family court, I would, but that's not why I'm here. So, ma'am, in looking at the lease, it looks like you're going to have to vacate the premises. However, I have serious concerns regarding the equity of the situation in terms of when you would have to vacate. So having said that, ma'am, when can you move?
He knows I have no place to go. I went to senior housing. They say it's a waiting list of 2 years, a minimum of a year. The shelter says unless you have kids, you're on a waiting list there too.
Have you guys been together?
Over 34 years. And then he keeps saying, if you give me 10 days, then he has till that day to change his.
No, we're, okay, hold on a moment. You guys have been living together 34 years?
Yes, and
Oh,
I've known
dear.
him 44 years.
All right, here's what I'm gonna do. Hang on one moment. No, when do we? Okay. That'd be fine. There are certain equitable issues, given the circumstances of this case, that the court believes it needs to decide. I'm going to set this matter for a final settlement conference and or final trial on June 28th, July 28th, 2023, 3:30 p.m. And that will be in person. And because I'm going to have to look at some things, because it seems to me that the only thing that separates this case from any others may be a marriage certificate. And I guess if somebody's been with somebody 34 years and wants me to use the court's power to kick them out, then they need to look me square in the eyes in person.
I will have,
July 28th,
I will have
3:30.
Mr. Eisenhower there, Your Honor.
Thank you.
And of course, I will be with him.
No, it's not your eyes I want to look into, but okay, thanks for coming. All right. Linden Park Apartments.
Thank you, Your
Ma'am,
Honor.
we'll see you then. Linden Park Apartments versus James Lewis.
Good morning, Your Honor. Andrew Gertis for the plaintiff, and appearing with me is Ashley Contreras from the plaintiff.
Mr. Lewis?
Yes, Your Honor.
Okay, there he is. Okay, where are we on this case, folks?
Your Honor, the plaintiff wishes just to proceed with the hearing.
Okay, I understand that. How much is owing at this point, counsel?
The rent to retain possession is $4,565. There are costs of $161.88. And the total owing for possession judgment would be $4,726.88.
Mr. Lewis, what do you have to say to that?
Well, Your Honor, yesterday I buried my son, and I've been having a rough time, Your Honor, and I can pay this if I have a little more time. I can pay it because I get retirement from the water department, and I have Social Security, Your Honor, and I can pay this.
Well, have you paid, sir, have you paid anything to the landlord since June 30th?
No, I haven't.
Well, on the June 30th hearing, you indicated you had $2,000 to pay and you haven't paid that over.
No, no, Your Honor, I haven't paid it because they found my son dead in Inkster, and I think somebody put something in his drink. So I don't know what the situation is, but I had to use that money. I thought I was gonna have it, but I had to use it for his service, Your Honor. And I certainly apologize if I could just get the time to pay this.
But you'll have to, sir, you'll have to deal with that with the landlord at this point, because I adjourned this hearing out a week, so hopefully folks can try to work things out. It doesn't look that way. So after hearing, the court is going to find that there's no tribal issue for the court. Judgment will enter for the plaintiff in the amount requested of $4,726.88 with the writ to issue. I'll give you a few more days so that if you can get that amount paid, then you can pay it, but writ will issue the 28th instead of the 24th. Thank you.
Thank you, Your Honor.
What was that, Your Honor?
I'm sorry.
I didn't understand that, Your Honor.
The order of eviction will not issue 10 days from today. It'll issue on the 28th. I'm giving you some extra time to try to get that amount paid over to the landlord.
Okay, thank you, Your Honor.
Thank you.
Thank you.
Mhm.
Court calls the case, Manchester Apartments versus Kathleen Downs.
Good morning, Your Honor.
She-
Attorney Sean Mock for the plaintiff. My property manager, Vicky Jordan, is also present.
All right, and on this case, I do have a signed consent or conditional order of dismissal. Is that correct?
Yes, Your Honor.
All right, Ms. Downs,
Yes.
do you have any questions regarding this
The
conditional
only,
order dismissal?
the only question that I have regarding this is that with the agreement, the payment agreement we made, does that include the month's rent?
That includes rent due through the month of July.
So it would be so we've got 3 separate payments that would each include the month that rent is due.
No, that doesn't. Although the payment agreement extends through October 15th, that only includes rent due through July. So you need to make your monthly rental payments in addition to these 3 monthly payments.
So it's an additional 500 and
Yes.
some. Okay.
Correct.
Okay. And then Judge Simpson, that was the agreement that we were able to come up with. It was a lot shorter than I had hoped. And I had hoped that the amount could have been lowered because of the situation that happened with me not getting recertified.
Okay, well, Ms. Downs, I have this consent order dismissal. You signed it, but if you don't want to sign it, then you could proceed in another direction. But this is something that was worked out between the parties, and I'm not gonna change it on my own, especially
Right.
after it's been signed. So,
Right. Well, it was brought up last time too, and the solution was just for us to come to an agreement. So that's.
if you could, but ma'am, if you don't have to agree to this. I mean, my signature is not on it. So you don't have to agree. And if you don't agree, then I'm not gonna sign it.
What did you say?
I said, if you don't agree, then I'm not gonna sign this.
Muted, correct? Yeah. He has.
Hold on a second. Can you, York Township, can you please, thank you. Did you understand me, ma'am? I'm not gonna sign this conditional order of dismissal if you still have questions about it or you don't agree.
Okay, I feel like something needs to be done about the amount of that back owed rent then. I thought that this was kind of like the option that I had to stay in the apartment.
Then I'm not gonna sign the conditional order of dismissal. What would you like me to do now on this case, counsel?
Well, Your Honor, the issue is, I believe Ms. Downs states she was unemployed for much of 2022 and into 2023. She alleges that she submitted a recertification packet over this past winter, but that the manager at that time, who is different than the current manager, either refused to process the recertification or told her just to wait for her annual recertification, which was coming up, I believe, in April. Obviously the plaintiff has no evidence, that she actually did attempt to recertify.
All right, well, here's what I'm gonna do. I'll set this for final settlement conference on July 28th. Be a busy day, 2023, 3:30 p.m. That's in person. And then we'll flush this out and whether or not we need to set a trial date on the issue or whether or not she recertified.
Very good. Thank you, Your Honor.
Okay, we'll see you on the 28th, Ms. Downs.
Okay, thank you.